Florida's unique stance: no transfer on death deeds allowed. Many people across the country want a simple way to pass their home to a loved one. They want to avoid the complexities and costs of the court system. In many states, a tool called a transfer on death deed serves this exact purpose. It is a straightforward document that allows a property owner to name a beneficiary who will automatically inherit the real estate upon the owner's death, bypassing the lengthy probate process. This sounds like an ideal solution for many families. However, this option is not available everywhere. Different states have different laws governing real estate transfers. Florida stands apart. It does not allow transfer on death deeds for real estate. If a Florida homeowner records a document that looks like a TOD deed, it won't have the intended legal effect. It will not transfer the property outside probate. This confuses many people moving from states where TOD deeds are common. Using an internet form can create significant problems down the road. Florida does not recognize transfer on death deeds for real estate. Recording a TOD-style deed generally won't accomplish the transfer and can cause confusion or delays. Instead of simplifying matters, an invalid deed can cloud title. The family will likely have to go to court anyway to sort out ownership. It can be more complicated and costly than standard probate. But Florida offers effective alternatives that avoid probate and preserve control. To understand the search for alternatives, first understand probate. Probate is the court-supervised process to settle an estate. Property owned in a decedent's name alone is essentially frozen. The court validates any will and appoints a personal representative. Debts and taxes are paid. Remaining assets are transferred to heirs. In Florida, straightforward probate can take 6 months to a year, longer if complex. Families may be unable to sell or take ownership during that time. Costs include filing fees, publication, administrative expenses, and attorney's fees. Attorney fees often scale with estate value, thousands or more. Probate is public. Many prefer privacy, time, and money savings, driving demand for probate avoidance tools. Since traditional TOD deeds aren't an option, Florida uses a powerful alternative. Florida recognizes enhanced life estate deeds, commonly called ladybird deeds. They achieve a similar result through a different legal mechanism. A ladybird deed is Florida's functional equivalent of a TOD deed. It splits ownership. The life tenant keeps control for life, and names remaindermen to take at death. The enhanced feature is the extensive power the owner retains. The property transfers to named beneficiaries upon the owner's death, while the owner keeps a life estate with enhanced powers: sell, mortgage, lease, and revoke, without beneficiary consent. This distinction preserves control. A proper ladybird deed avoids probate for the real estate. Typically, beneficiaries record a death certificate to clear title, saving time, money, and stress. Another probate avoidance tool is the traditional life estate deed. It is similar in structure but differs in control. Like a ladybird deed, it creates a life tenant and a remainder man. At the life tenant's death, ownership vests in the remainder man outside probate. But once recorded, the life tenant cannot sell, mortgage, or transfer without the remainder man's consent. The remainder man's vested interest means their signature is required. If needs change, accessing equity or moving, lack of consent can trap the owner. The remainder man's creditors may attach liens to their future interest. Due to restrictions, traditional life estates are used less often than ladybird deeds or living trusts. For maximum flexibility and control, a revocable living trust is often the gold standard. Placing real estate into a revocable living trust is a common Florida strategy. You transfer the property during your lifetime, and the trust controls what happens after death. Step 1. Your attorney drafts the trust. You typically serve as trustee. You keep full control and name a successor trustee for incapacity or death. Step 2. Fund the trust by retitling assets into it. For real estate, sign a new deed, often a quitclaim or warranty deed, to your name as trustee. Once in the trust, the house is no longer part of your probate estate. As trustee, you can still sell, refinance, and manage the property. The trust is revocable. You can change or dissolve it. A trust can hold many assets, avoiding probate across your estate and planning for incapacity. Downsides: higher setup cost and complexity. The most common mistake is failing to fund the trust. Then assets still go through probate. Medicaid can recover certain benefits from probate estates. In Florida, recovery is generally limited to the probate estate. Because a ladybird deed passes property outside probate, it is usually not subject to estate recovery. This protection helps many modest income families keep the home. Trusts also avoid probate, but Medicaid rules for trusts can be more complex and term-dependent. Medicaid rules are complex and change. Get advice from a Florida elder law attorney. Mistakes can affect eligibility when it matters most. Florida's rules can feel overwhelming, but a structured approach helps. Do not use a standard TOD deed form in Florida. TOD deeds for real estate are not allowed here. Learn valid alternatives. The Enhanced Life Estate, Ladybird, Traditional Life Estate, and Revocable Living Trust. Clarify goals. Single heir or multiple beneficiaries? Need absolute control or willing to share? Assemble your asset list, family structure, and future care considerations, including potential Medicaid. Consult a qualified Florida estate planning or elder law attorney to draft the right documents, Ladybird deed, trust, or both, so your wishes are carried out and your family is protected.